Ladies and gentlemen, that concludes the prosecution's opening argument to you. What is next is the defense argument. All right, the record should reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. And as I mentioned to you, we had some preliminary matters we had to take up out of your presence. We're now ready to proceed with the defense argument. Mr. Cochran.
Thank you very
may
much. Judge Ito, my colleagues on the defense, my colleagues in the prosecution, the Goldman family, the Brown family, to the Simpson family. Good afternoon, ladies and gentlemen. The defendant, Mr. Orenthal James Simpson, is now afforded an opportunity to argue the case, if you will. But I'm not going to argue with you, ladies and gentlemen. What I'm going to do is to try and discuss the reasonable inferences which I feel can be drawn from this evidence. At the outset, let me join with the others in thanking you for the service that you've rendered. You are truly a marvelous jury. The longest serving jury in Los Angeles County, perhaps the most patient and healthy jury we've ever seen. I hope that your health and your good health continues. We met approximately 1 year and 1 day ago, on September 26, 1994. I guess we've been together longer than some relationships, as it were. But we've had a unique relationship in this matter in that you've been the judges of the facts. We have been advocates on both sides. The judge has been the judge of the law. We all understand our various roles in this endeavor that I'm going to call a journey toward justice. That's what we're going to be talking about this afternoon as I seek to address you. The final test of your service as jurors will not lie in the fact that you've stayed here more than a year, but will lie in the quality of the verdict that you render and whether or not that verdict bespeaks justice as we move towards justice. Now, you'll recall during a process called voir dire examination, each of you were thoroughly questioned by the lawyers. You probably thought, gee, I wish they'd leave me alone. But you understood, I'm sure, that this is very serious business. Our client, Mr. Orenthal James Simpson, is on trial for his life. And so we had to be very, very careful, both sides, in trying to get people who could be fair to both sides. You'll recall those questions, that you keep an open mind, which I hope you still have even to this day, that you wouldn't be swayed by sympathy for or passion against either side in this case, that you would give both sides of this lawsuit the benefit of your individual opinion. No one can tell you what the facts are. That's going to be your job to determine. It's not a question of age or experience. We talked about that. This is one of those jobs where you kind of learn on the job. And so it's important that you fully understand that. And that's why voir dire was so very important, as we ask you all of those questions before you were sequestered, before you were actually picked. Now, each of you filled out the questionnaire, and you answered the questions honestly, I'm sure. Now, Cicero said a long time ago that he who violates his oath profanes the divinity of faith itself. And of course, both sides of this lawsuit have faith that you live up to your promises. And I'm sure you'll do that. You know, Abraham Lincoln said that jury service is the highest act of citizenship. So if it's any consolation to you, you've been involved in that very highest act of citizenship. And so again, we applaud you and we thank you as we move toward justice. One other entity or group of ladies, or two ladies that I should thank, are our marvelous court reporters. They have been patient with us. They've been here from the very beginning. We very much appreciate them and their services. And I especially appreciate them because sometimes I speak rather rapidly and they have a tough time keeping up with me. So I trust that today, if I start to speak too fast in my zeal, Ms. Moxham and Chris will bring that to my attention. I'm sure they will. Now, in the course of this process where we're discussing the reasonable inferences of the evidence, I ask you to remember that we're all advocates. We're all officers of this court. I will recall the evidence and speak about the evidence. Should I misstate that evidence, please don't hold that against Mr. Simpson. I will never intentionally do that. In fact, I think you'll find that during my presentation, unlike my learned colleagues on the other side, I'm going to read you testimony, what the witnesses actually said, so there'll be no misunderstanding about what was said about certain key things. But remember that we're all advocates. And I think it was Ms. Clark who said, saying it so doesn't make it so. I think that applies very much to their arguments. Ultimately, it's what you determine to be the facts. It's what's going to be important. And all of us will live with that. You are empowered to do justice. You are empowered to ensure that this great system of ours works. Listen for a moment, will you please? One of my favorite people in history is the great Frederick Douglass. He said shortly after the slaves were freed, quote, "In a composite nation like ours, as before the law, there should be no rich, no poor, no high, no low, no white, no black, but common country, common citizenship, equal rights, and a common destiny." This marvelous statement was made more than 100 years ago. It's an ideal worth striving for, and one that we still strive for. We haven't reached this goal yet, but certainly in this great country of ours, we're trying. With a jury such as this, we hope we can do that in this particular case. Now, in this case, you're aware that we represent Mr. Orenthal James Simpson. The prosecution never calls him Mr. Orenthal James Simpson. They call him defendant. I want to tell you right at the outset that Orenthal James Simpson, like all defendants, is presumed to be innocent. He's entitled to the same dignity and respect as all the rest of us. As he sits over there now, he's cloaked in a presumption of innocence. You will determine the facts of whether or not he's set free to walk out those doors or whether he spends the rest of his life in prison. But he's Orenthal James Simpson. He's not just the defendant. And we on the defense are proud, consider it a privilege to have been part of representing him in this exercise and this journey toward justice. Make no mistake about it. Finally, I apologize to you for the length that this journey has taken. But you know, when you're seeking justice, there are no shortcuts. If you were to trade places with either side, you'd want someone who'd fight hard for you and vigorously, especially if it was a person who had maintained their innocence from the very beginning of the proceedings. Some of you in voir dire talked about that. You've been involved in other cases where you felt the lawyers didn't stand up. Well, I certainly hope that in this case, on both sides, you felt the lawyers did their best to represent their respective positions, and we will continue, I'm sure, to do that, so that, although I apologize for the length of the trial, I hope and I trust that you will understand that in a journey toward justice, there is no shortcut. Finally, with regard to your responsibilities, we ask you at the very beginning to don't compromise. This is not a case for the timid or the weak of heart. This is not a case for the naive. This is a case for courageous citizens who believe in the Constitution. And while I'm talking about the Constitution, think with me for a moment. How many times you heard my learned adversaries say, the defense didn't prove, the defense didn't do this, the defense didn't do that. Remember, back in voir dire, what did the judge tell us? Judge Ito said the defense could sit here and do absolutely nothing. One of you is from Missouri, and he reminded you, who's from Missouri here? Say to the prosecution, you show us. Now, we didn't do that. But we don't have an obligation, as you'll see. You've heard from the jury's instructions, and at the end I will show you some others. We don't have to do anything. We don't have to prove anything. This is the prosecution's burden. And we can't let them turn the Constitution on its head. We can't let them get away from their burden. My job, one of my jobs, is to remind you of that, and to remind them of that, that that's their burden. They must prove Mr. Simpson guilty beyond a reasonable doubt and to a moral certainty, and we will talk about what a reasonable doubt means. And so now, as we have this opportunity to analyze the facts of the case, I agree with one thing that Mr. Darden said. To this task, I ask you to bring your common sense. Collectively, the 14 of you have more than 500 years of experience. I know you're all young, but if you multiply by 14, you won't hold that against me, I don't think. 500 years of experience. You didn't leave your common sense out in that hallway when you came in here. And we're going to ask you to apply it to the facts of this case. I'd like to comment and to compliment Ms. Clark and Mr. Darden on what I thought were fine arguments yesterday. I don't agree with much of what they said, but I listened intently, as I hope you'll do with me. And together, hopefully, these discussions are going to be helpful to you in trying to arrive at a decision. In this case, where you don't compromise, where you don't do violence to your conscience, but you do the right thing. And you are the ones who are empowered to determine what is the right thing. Let me ask each of you a question. Have you ever in your life been falsely accused of something? Have you ever been falsely accused? Have you had to sit there and take it and watch the proceedings and wait and wait and wait, all the while knowing you didn't do it? All you could do during such a process is to really maintain your dignity. Isn't that correct? Knowing that you were innocent, but maintaining your dignity and remembering always that all you're left with after a crisis is your conduct during it. So that's another reason why we're proud to represent this man who's maintained his innocence and has conducted himself with dignity throughout these proceedings. Now, last night, as I thought about the arguments of my colleagues, two words came to mind. And I asked my wife this morning to get the dictionary out and look up two words. The two words were speculative and cynical. Let me see if I can get those words that she got from me. Excuse me 1 second. I asked her, as I was thinking about this case, to go to Webster's, and I want you to tell me what does it mean to speculate? What does it mean to be cynical? As I thought about my colleagues' arguments and their approach to this case and their view of this case. Cynical is described as contemptuously distrustful of human nature and motives, gloomy, distrustful view of life. And to speculate, to engage in conjecture and to surmise, or is to take to be the truth on the basis of insufficient evidence. I mentioned those two definitions to you because I felt that much of what we heard yesterday and again this morning was mere speculation. Understand this, ladies and gentlemen, that none of us in this courtroom were out at 875 Bundy on June 12th, 1994, after 10:30 or 10:45 in the evening. So that everything we say to you is our best effort to piece together what took place in this case. When people theorize about things that may have been and talk to you about short fuses, you're going to see that's just that. It's speculation. People see things that are totally cynical. Maybe that's their view of the world. Not everybody shares that view. Now, in this case, and this is a homicide case and a very, very, very serious case. And, of course, it's important for us to understand that. It is a sad fact that in American society, a large number of people are murdered each year. Violence, unfortunately, has become a way of life in America. And so when this sort of tragedy does in fact happen, it becomes the business of the police to step up and to step in and to take charge of the matter. A good, efficient, competent, non-corrupt police department will carefully set about the business of investigating homicides. They won't rush to judgment. They won't be bound by an obsession to win at all costs. They will set about trying to apprehend the killer or killers and trying to protect the innocent from suspicion. In this case, the victims' families had an absolute right to demand exactly just that in this case. But it was clear, unfortunately, that in this case, there was another agenda. From the very first orders issued by the LAPD so-called brass, they were more concerned with their own images, the publicity that might be generated from this case, than they were in doing professional police work. That's why this case has become such a hallmark. And that's why Mr. Simpson is the one on trial. But your verdict in this case will go far beyond the walls of Department 103, because your verdict talks about justice in America, and it talks about the police and whether they're above the law, and it looks at the police perhaps as though they haven't been looked at very recently. Remember, I told you this is not for the naive, the faint of heart, or the timid. So it seems to us that the evidence shows that professional police work took a back seat right at the beginning. Untrained officers trampled. Remember, I used the words in the opening statement. They traipsed through the witness, through the evidence. And it was interesting because the prosecution didn't agree with that at the beginning, but later on in this trial, we heard Mr. Goldberg and talking to witnesses use my words, traipsing through the witness scene. That scene there at Bundy. He used our words because they understood. We knew what we were talking about. We were able to demonstrate it through the videos. They delayed unconscionably routine procedures in notifying the coroners. They didn't call the criminalists out on time. And yes, they allowed this investigation to be infected by a dishonest and corrupt detective. They did that in this case. And they may try to back away from it all they want, but that's very important, as you're going to see, to this case and the resolution of my client's innocence. Because of their bumbling, they ignored the obvious clues. They didn't pick up paper at the scene with prints on it. Because of their vanity, they very soon pretended to solve this crime, and we think implicated an innocent man. And they never, ever looked for anyone else. We think if they'd done their job as we have done, Mr. Simpson would have been eliminated early on. And so this case is not, let me say at the outset, is not about attacking the Los Angeles Police Department. We're not anti-police in making these statements. You're not anti-police. We all need the police. I just said we have so much crime in this country, we need the police. But what we need, and what we must demand, what all of us should have, are honest, effective, non-biased police officers. Who could demand less? Can any of you say that's not what we should have? And so, let me tell you about how we're going to proceed here this afternoon. The defense has one opportunity, basically, to address you. This is after the prosecutors are finished. I will address you first. And after I'm concluded, and I will talk generally about the lay witnesses and an overview of the evidence and what you've heard. I'll strive not to bore you. I'll strive to be honest in my discussions, to be relevant, to be concise in what we talk about here. When I'm finished, Mr. Barry Scheck will come before you and address some of the forensic issues. And then finally, after Mr. Scheck finishes, I'll come back and conclude some concluding remarks regarding what you've heard over the course of the last 2 days at any rate. Now you understand that because the prosecution bears the burden, in this case and in all cases, Ms. Clark will argue last to seek to rebut that which we bring up. And presumably she won't be back up here talking about all kind of new things. Seek to rebut that which we bring up. And let me tell you in front, if she brings up anything, we may be precluded from standing up and saying, wait a minute, Your Honor, here's the answer to that. But you can then substitute your common sense, your judgment in that place. And that's required in this journey toward justice. Now, at the outset, let's talk about this timeline for the defense. I said earlier that Mr. Darden did a good job in his argument. But one thing he tended to trip over and stumble over was when he started to try to talk about our case. He doesn't know our case like we know our case. It was interesting, wasn't it? Because first he stood up and started talking about the timeline being at 10:15. Then he said, well, they didn't prove anything, but golly, well, it may have been as late as 10:30. That's interesting, isn't it? Never heard that before. You look back and see what Ms. Clark promised you a year ago. 10:15. 10:15 was all they talked about. And they were going to use, because of the incompetence of this investigation, the wail of a dog. So we've been relegated to, in this case, because of this very, very poor investigation. But having said the defense doesn't have to prove anything, in this case, we did, in fact. And so Mr. Darden could talk all he wanted to about his theories about motive. They're just that, his speculative theories about motive. But when it came down to the end, he wasn't talking about motive, was he? He was trying to talk about our timeline. Why would he do that? Let's talk about why he would. Because the defense in this case called many witnesses who corroborate each other and who shatter the prosecution's timeline. Now, these are witnesses to a person who were known by the prosecution but discarded by the prosecution. Why? Because they didn't fit their tortured, narrow window of opportunity. So when you would visualize for me that jigsaw puzzle, where they want to reduce this case down to a jigsaw puzzle, the part that deals with opportunity is the timeline. And we're going to start off with that, because in a search for truth, let's look for the truth. Not some contorted, twisted truth, but the real truth, the facts that you've heard during the course of this particular case. We think after you look at this timeline for the defense, you will agree with our early analysis. This is a case about a rush to judgment, a case where there's been an obsession to win at all costs. And in the words of Dr. Henry Lee, something is wrong with the prosecution's case. Let's start off with Francesca Harmon. Francesca Harmon is the lady who left the dinner party on Dorothy at about 10:20 p.m. She drove west on Dorothy and Bundy and turned north on Bundy, so she'd be heading north toward 875. She saw nothing, heard nothing, no barking dogs. It's a lady known, of course, to both sides. And so you see this graphic regarding Francesca Harmon. And I think to familiarize you with that, I think at 10:20, so I understand that's the approximate time that she would pass by or near Nicole Brown Simpson's home there. Oh, you see it with the X mark there in this graphic. That's Miss Harmon. We followed Francesca Harmon with Ellen Aronson and Dan Mandel. Remember the two people who'd been on their first date? They'd gone to Metzaluna. And they were interesting young people. I think you would find them credible. And by the way, you hold all witnesses up to the same standard. No side has a priority on the truth. These are witnesses known to both sides. We're the ones, however, who elected to call them and bring them here for you. You know how they walked home from this first date at Metzaluna, walking directly by the walkway at 875 South Bundy. And they said they passed by there. Remember, they were clear. They passed by there at 10:25. And you'll see the little kind of purple lines. Shows you the route they took. So they passed right in front of Miss Nicole Brown Simpson's home at 10:25. And you remember, they continued on. So they were over on Darlington Street by 10:29. She said that it took them about 4 minutes from the time they passed 875 South Bundy to get home that evening. This was their first date, and I guess, as I recall, this was also their last date. They saw no blood. They saw no barking dogs. I submit to you, if the bodies had been there, they could have been seen. Now, why do I say that? I say that because we have a contact print in evidence. And I'm going to ask Mr. Harris, if he can, to show us this contact print. This is an item you'll be able to take back in the jury room. Now, this is a photograph taken by Mr. Rokar at night, and it will let you see, Mr. Harris gets it focused, that scene that particular night. What you could see with regard to this body, Your Honor, you may want to cut the feed on part of this. .33, Howard. This exhibit, number 86, was a photograph that we got late in the trial from Mr. Rokar. The photographer was called by us. You see that document over there? That's a contact sheet. Remember, he talked about all of these photographs in sequence in this first roll were taken at night. This is going to be a very, very important role for you as this case progresses. This is a photograph at night of what you could see from across the street, and there were lights in and around there. And so when Mr. Darden stands up here as an advocate and tells you it was pitch black and you couldn't see anything, this is the photograph that was taken before the sun came up. This photograph was taken at night. It's not pitch black. We know also that according to the evidence, blood had flown down that walkway. There were bloody paw prints that went southbound on Bundy there. So you see that photograph? You see that photograph? Now you can be an advocate, and we're all sworn to do the right thing. He talked about his oath. Well, your oath is also to tell the truth. It's not pitch black. We have the evidence. And I'm going to try to do that throughout. Where they have misled you or not said things that weren't correct, I'm going to try to straighten it out for you. Mr. Harris, why don't you tell the court now what that number is? It's number 1369, and that's Mr. Rokar. We're going to come back to some other photographs on that, but you'll recall his testimony. And the reason why 1369 is so important is because it is undisputed that at 10:25, Mandel and Aronson walked past there. If there was blood down on that sidewalk, if there had been a killing had taken place, if there were dogs barking or wailing, don't you think, given that, if you've been out there, you'd see it. So the time has come now to stop all this folly and fantasy. Let's deal in reality and in the facts of what took place and what you can see with your own eyes. I don't want you to speculate or theorize. When I sit down, I want you to understand what the facts are of this case. Hey, Mr. Harris, you can take that down. After that, we had Denise Pilnack and Judy Chilander. And I think, again, as advocates, we have a responsibility to treat all of these witnesses with respect. These people didn't ask to come down here. These people don't ask to be maligned. I don't think anybody really wants that, with the exception of one or two. And most of them were called by the prosecution. So when Denise Pilnack, the lady who wore 2 watches, comes in here and tells you, I ask you to judge her credibility like you do all the witnesses. The court has instructed you. You hold all witnesses up to the same standard. You look at the reasonableness of what they have to say. You look at their bias or interest. You look at their demeanor on the stand.